So I also sent you, I believe, 5 motions. Have you received those?
No, ma'am, I have not.
They were mailed last week.
Then I have not received them yet. The last correspondence I got from you, ma'am, was received on July 8th.
5 motions I've mailed. They're probably sitting wherever else it is, considering it takes a day for you all to receive my mail, considering I'm right down the street from you all. So I have those also in order, which may change whatever information or anything that I'm trying to acquire in between now, the month less that I have in order to prepare for my trial. That's in October. So if you could keep an eye out for those also. I don't think you have enough time. I'm just doing my best. And if you could please keep an eye out for my motions.
I will be on the lookout for them. You said there were 5, correct?
Yeah.
Well, hello, my little boonies. There's been a lot of activity on the Clerk of Court's website this week. It seems like since their last little surprise meeting on 7/25 that the court has stepped up and gotten a lot of things in order here. And it does look like a lot of things have been sent over to Sarah in the last several days. Court is still set for September the 24th, trial management conference, followed by the actual trial to begin on October the 7th. It's really not that far away. We are going to have a hearing on Monday, so we'll be back in the courtroom for that. Until then, let's go over all this correspondence that's been uploaded to the docket. Okay, we'll start with the motions. Okay, so she's basically put together her motions as she's seen prior to how they've been done. And all in all, she's asking for, I'm not going to read all these word by word because it gets there's a lot here. And it's a lot of legal verbiage. We're going to get straight to what she's asking for. She wants money for an investigator. She wants money for standby counsel. She wants money to oppose or acquire witnesses. She wants a proper workspace somewhere at the jail where she can privately work on her case. And she wants phone access because apparently right now they can call out, but it's collect call and they only get like 15 minutes every call. So it makes it difficult for her. And honestly, all this stuff that she's asking for, it's pretty general. It's pretty, she should get these things. I'm pretty certain she should get these things. But here's the way they responded to it. Now, she wrote this prior to them getting together on the 25th of July. And on the 25th of July, she was assigned I guess she was made notice of the investigator who was involved. And God bless that poor man. We're worried about him and how he's going to get through till the next hearing. I wonder how many letters and phone calls she's made to him. So that she got already. Now, what's happened since July 25th is that the court has responded to these motions. And I'll read off their response here. The defendant is seeking authorization for various due process costs as follows: appointment of standby counsel to assist the defendant, costs to take depositions, an unspecified amount for a defense investigator, unspecified expert witnesses to assist the defense, and costs for unspecified witnesses to appear at trial. Oh, she thinks she's just going to pay people to come and appear for her. I didn't realize she putting that in there. I guess she doesn't know how to write it all out. Let me see how do I put this? She's over requesting in a sense because she's not really sure how she's supposed to ask for it. She's going to ask for it like in more than one way. All right. So as initial concern, any future requests for due process costs, such as requests for transcripts, investigative costs, or experts, need to be served on JAC prior to the court considering the matter. The defendant is responsible for providing JAC with any motions for due process costs so that the JAC can respond accordingly to those requests. I do see where this is she's going to be, I bet she is so pissed, you guys, because basically she's like, oh my gosh, I just got all this stuff. I'm trying to read through it. And how do I know what all it's supposed to cost? I'm not sure what it's supposed to cost. How am I supposed to get in touch with these people to find out what they're going to bill me for? It says the JAC may only pay for due process costs pursuant to section blah, 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 blah. And she's probably reading this going, oh, great. Now I have to look up the section 29, 27, and 27 Florida statutes. Number 4, as directed by section 27 Florida statutes and the General Appropriations Act, all due process services are subject to the Florida statutes and the JAC contract policies and procedures. JAC objects to any compensation rate in excess of established rates. Well, where do I find the rates? Nobody's telling me what the rates are. Oh my God, this is so hard. Number 5, standby counsel. As for the appointment of standby counsel, the court entered an order on June the 28th, finding that the defendant waived her right to court-appointed counsel through her conduct in this matter. Thus, the court has already ruled on this issue of appointed counsel. Dang. So they're not even going to give her standby counsel, you guys. Oh, but honestly, I know I get why they're saying that, because she would only abuse the standby counsel. The judge is basically saying, look, no, I mean, normally, yeah, I might, in a normal situation, we would appoint standby counsel, but this is by no means is this case normal. This woman has basically belittled, berated everything about all these previous attorneys. I'm not going to put a standby counsel there for her to abuse. Okay, so then they got the deposition related cost. As for cost to take deposition, the defendant is authorized to incur costs to take depositions for those depositions authorized under the Florida Rules of Criminal Procedures. The notice of taking deposition substitutes for a court order for purposes of the court reporter seeking compensation for appearance fees. As for service of process, service must be through the sheriff unless the sheriff is unable or unavailable to provide service of process. In those instances where private service of process is necessary, a separate motion to incur costs for a private process server will be required. The sheriff must be used to serve in county law enforcement. Okay. As for transcripts, JAC has no objections to regular paid rates. The motion and order for transcripts must reflect sufficient information to identify the proceedings to be transcribed, such as the type and date of hearing, date and type of hearing, and recording type and date of recording. The defendant should only order those transcripts necessary for defense of the case. The unified statewide rates are set forth in the General Appropriations Act. Court reporting services cannot exceed these rates. Well, then, oh my God, how do I find out what the rates are? What am I supposed to do? Oh, this is ridiculous. I'm writing a letter. Who do I talk to? I bet, y'all, she's going to be going back to this poor Mr. Lane, the investigator, and asking him way too many questions, because he's the only person that she can contact right now that has any contact with the court. So she's going to automatically assume that he knows every step that she's supposed to take. And he's probably going to tell her, ma'am, I'm not an attorney. I don't know. I can refer you to somebody that might can help you, but they're going to charge you. I guarantee you, Sarah's already made a phone call to Brian, her ex-husband, and it's like, you need to pay for me to get somebody to help me understand all this. I need somebody who can look at all this stuff and walk me through it so that I can defend myself. I cannot believe they're putting me through this.
I've been here for 4 years and I'm tired of being here and I'm tired of going through all of these attorneys, which are not my fault. But when 100 days have passed and I haven't heard or said or done anything other than try to figure out where you are because your phone doesn't work, I'm not a bad person because of that.
All right, private investigator costs. Pursuant to the uniform statewide rates, the rates of investigators cannot exceed $50 per hour. But she's already been assigned an investigator, so I think this is kind of a moot point, but let's see. As required by Florida law, any private investigator providing services in Florida must have a Class C license from the Department of Agriculture and Consumer Services and be employed by the investigation agency with a Class A license. If the court grants the motion, the order needs to indicate the amount authorized for defense investigator. Based on docket, it appears Prison Break Investigations, Billy Lane, may have already been appointed to this matter. JAC does not object to the court authorizing $5,000 for a defense investigator and $500 for the investigator to obtain case-related documents and materials on behalf of the defendant. Now, let's see. What's today? The day's the 1st. All right. So it's been almost a week. or has it been a week since they went to court? Do you guys think she's used up that $5,000 yet? Probably. All right, the experts cost. Now, when she says experts, obviously she's talking about expert witnesses. And in her case, where everybody was leaning, they were leaning toward domestic abuse. So it could be that this is where she's going with her defense now, is she's going to have somebody come in and say that she was the victim in all of this. Based on JAC's records, the court previously approved $3,000 at a rate of $200 per hour for a defense mental health expert. JAC does not object to the court continuing this authorization now that the defendant is representing herself. As to other requests for other experts, the defendants will need to file an appropriate motion delineating the following: identity or type of expert, amount authorized for the expert services, and rates authorized for the expert services. Well, how do I know what they're going to charge? I can't believe this is not my fault. I excel at everything I do, and this is just not satisfactory. This is not up to my standards. There's no way that I can figure all this out in time for me to go to court. There's just no way. That's what she's going to be saying. Now that she's gotten all this, in the next hearing on Monday, she's going to be whining about how none of this is fair to her and that she doesn't have enough time. The defendant has the burden to show particularized need for each expert witness. The defendant needs to show the services of the expert is necessary for the defense of the case. As enunciated by the Florida Supreme Court, a party seeking due process cost has the burden to establish 1, the particularized need for due process services, 2, prejudice arising from the denial of due process services. And then they tell her to go look at they reference a case and she's like, oh my God, now I gotta look this up. Where do I find it? I need the library. Take me to the library now. I gotta go to the library. There's like 3 cases here they've shown her. So the time it's going to take her to look these up and read them and understand them is going to be insane. All right. Then it says, the determination of whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant must show the trial court that there exists a reasonable probability both that an expert would be of assistance to the defense and that denial of expert assistance would result in a fundamentally unfair trial. And then there's 2 more cases referenced here. Here's where immediately, this is what I'm thinking. She's going in and she's going to look up these cases. And on her mind, she's thinking, and while I'm in here, I'm going to make side notes about unfair trial. And I'm going to bring up this at some point in time that this is not fair. Them making me defend myself and not allowing me to have an attorney is just, and not giving me more time to find a new attorney. Guarantee you that's what she's saying. Okay, cost of ordinary witnesses. The defendant will need to submit a more detailed motion delineating the witnesses she seeks to summon for trial and the anticipated cost associated with these witnesses. But just a side note, Sarah, you can't pay nobody to say you was innocent, girl. Okay, requirement for JAC due process contract. If any providers desire direct payment, the JAC's procedures require the vendor to execute the appropriate contract and follow JAC's billing and audit procedures to obtain payment. Because of the unusual circumstances presented in this matter, JAC requests participant in the hearing set on August 5th. JAC requests to appear through communications equipment and can be reached toll-free. Oh, Lord, they gave her the phone number. Toll-free at 866-355-7902. Wait, can she call a toll-free number from jail? Because they still have to accept the call, right? There's still a charge for her to call out. Oh, that's going to be a nightmare. She's already on the phone. Can you imagine? Okay, this is what I have in my head. It's scary what I have in my head, but part of it is Sarah standing at the phones, at the pay phones there in the jail, trying to figure out why, calling this number over and over again, then calling Mr. Lane, then calling Brian and bitching how she can't get anybody to answer. Brian, I need you to call this number and tell them what I'm trying to do. I've got to speak with them. Well, then you're just going to have, I wonder how long it's going to take her to realize that she could get Brian on a three-way. Get Brian to call the number while she's on the phone with them. And then they'll just have a three-way call. Meanwhile, poor Brian, who did divorce her a while back here, is still stuck with this woman and her problems. All because she was the mother of his child. Okay. Wherefore, the JAC request, should the court grant the defendant's motion, also include in its order the specific due process services authorized, as well as hourly or per unit rates and maximum fees authorized, and that the provider be paid in accordance with rates, terms, and conditions set forth by Florida statutes and the JAC contract, policies, and procedures. All right, so that's the first response. Oh, she is livid. When she read that they weren't going to help give her standby counsel, I bet she flipped her lid. Y'all know. This is not fair. This is not fair. Okay, what was the other document I was going to show you guys? Because there's been several things uploaded. So there's a jail notice here that on July the 24th, in regards to inmate Boone, Gina D. Giovanni, she's the captain of security operations, sent this to lieutenants and sergeants at the FDC security operations, obviously where Sarah is detained. And it says, the above inmate will be representing herself in the case of State versus Sarah Boone. The state attorney's office has been ordered to provide the inmate with discovery to review for court preparation. The laptop is currently secured and will be issued to inmate Boone upon her return from court, August the 5th of 2024. Oh, so I didn't even think about that. She doesn't even have the laptop right now. So at this point, when she gets back into the court on Monday, she will not have had the laptop and had time to, I guess, feel her way through things, look at some of this discovery stuff. So there's going to be even more questions there because of that. It says once the SAO provides the USB, I guess that's once she gets the USB devices to Correctional Sergeant Casey, Transportation Sergeant. So here's what the jail has been instructed to do. Upon receipt of these items, the laptop, charging cable, and USB device will be kept in the FDC main control room when not in use. This next statement is in bold. At no time will the charging cord be placed in the housing unit. Upon the return of the laptop to the FDC main control, the laptop will be placed on the charging cable to ensure it is available for the next day's usage. The laptop and the USB device is to be accounted for with the control room inventory. The control room will make logbook entries for the issuing and returning the USB device and laptop. The dorm officer will make logbook entries for the receiving and returning of these items to the applicable movement officer. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to inmate Boone. What's great about this is that they're going to be tracking her time working on her case, which I think she will. I mean, let's face it, she's going to be in there like a conspiracy theorist trying to go through all this stuff. The laptop and USB device will be available daily to inmate Boone between 800 and 1600 hours, which I know you guys, okay, that's 8 a.m. to 4 p.m. I said it wrong last time. In my last video, I said 8 a.m. to 8 p.m. Okay. This process will commence once all equipment devices have been received August the 5th. Upon receipt of these items, this process will need to be discussed in briefings to minimize any displacements loss of the evidentiary items. Please contact me should you have any questions. Any changes to this process will be communicated in writing. So they're basically just putting it down that, look, we got to follow these rules and guidelines. We have to have accountability on our side that she's getting everything she needs, and we need to log it so that outside of the courtroom, there is some kind of documentation of what's going on here with the discovery items. And also we have to account for this laptop. Okay. The next thing, they have uploaded what they're going to be going over on Monday, August the 5th in the hearing. And this is their notice to her. We're having a hearing. We've said it in court already, but we're telling you in writing, there's a hearing on August 5th of 2024 at 8:45 a.m. And obviously, and you know, this isn't normal. They do this with every hearing. I don't know if they, you know what? I'm going to pull back on that statement because I could be wrong about how they do put notice of hearings out, obviously. But I don't know if they go into this much detail of what they're going to be discussing at the hearing. And they probably, if they don't normally do this, they're doing this specifically for Sarah to understand what to expect and not ask so many damn questions. And I get this. I mean, again, crossing T's and dotting I's, right? Okay. So they're going to schedule a deadline regarding production of state's exhibits and defendant's exhibits. They're going to schedule a conference for the defendant to review all of state's exhibits in the courtroom 12A. So they've got to have a separate time set aside for them to go back into the courtroom and let her see all of the evidence. Wow. Okay. Scheduling a deadline for receiving defendant's objections to state's exhibits. Scheduling a conference. These are basically setting deadlines. Scheduling a conference for the state to view all the defendant's exhibits in courtroom 12A. $20 says that there's no way they're going to not go back to court before the September 24th conference hearing. I would imagine they're going to reschedule some more stuff probably in the next 2 weeks to kind of stay on track of this. Scheduling a deadline for receiving state's objection to the defendant's exhibits. Scheduling a deadline regarding production of state's witness list and defendant's witness list. Scheduling a deadline for receiving defendant's objections to state witness list. Scheduling a deadline for receiving state's objection to defendant's witness list. And the defendant's temporary motion for reservation of proposed cost to acquire investigator for defendant's defense in the trial dated July the 18th and received July 29th. Defendant's temporary motion for reservation of proposed cost. Okay. So they're going to go over her motions. All of them here. All 5 of them. So that's what we're going to get on Monday. I have a feeling that this poor judge is going to have to spend a lot more time with Sarah than he wants to. Because there's no way she's not going to ask 20 million questions. That being said, he was pretty matter of fact in the last meeting. When she started asking questions, he was like, ma'am, I cannot answer that question. You have been charged to defend yourself, and I'm not. She's going to be, she's going to wish she had Judge Duro. Let me put it that way. Oh my God, I would love to have seen her and Judge Duro together. That would have been awesome. All right, what else we got here on the docket? This is just going over the minutes from the last court meeting where they basically said, you know, meet investigator Billy Lane. He's with Prison Break Investigations. He's assigned to your case. Where the judge also told him, look, do whatever you got to do to get all of the discovery on a USB drive or USB drives, plural, so that we can get it over to her. So it's going to be them handing stuff over on August the 5th, and she's going to stay in court on August the 5th. I cannot believe that between the last time that we met and now, you have not given me any more information. I'm still waiting for my discovery items. I have lost a week's worth of time in working on my case. And then she's probably going to ask him again for an extension. And he's going to say, nope, I told you, nope. So at that point, on Monday, he's got to turn this USB drive over to a representative from the Orange County Jail so that they can place it onto the laptop that is currently just secured and issued to the defendant for the court trial preparations. Looks like that's it. So today's Thursday that I'm recording this, and we'll have to wait till Monday to see what happens from here. So you guys, basically, you now have everything that was on the court docket. There was some correspondence on July the 31st, but it's locked. So I don't know what that's all about. When it's not a letter though, because let me make sure I'm saying this correctly. No, it could be a letter, because in a previous thing on the docket, let me share this. So like her 58-page letter that she sent, that was uploaded on 6/21, they show that as just correspondence too. So yeah, I can imagine that Sarah's already written a letter. But at the same time, I don't know if it would have been uploaded within a day. Well, no. She's had since the 25th. Yep, guarantee you that's another letter from Sarah. But I wonder why they would be keeping it out. It might have some information in it that should not get out to the public yet until trial. So that's where we stand. I would like to thank you all for being here with me when it comes to Sarah Boone and her craziness. I know there's a lot of other places you could be. And if you want any legal advice on this case, feel free to go check out a lawyer on YouTube, because I am not an attorney, nor do I claim to be one, nor have I ever said that I know what I'm talking about here on my channel. I am here for entertainment purposes only. I like to make fun of people. I like to make you all laugh. Thank you for watching, everyone. And listen, if you were enjoying those weekly crime news reports that I was doing, where we hopped around from topic to topic and gave about 2 to 3 minutes on each, I have started a sub-channel dedicated to crime news only. So please check out the link to that channel down in the description box below. And if you don't mind, subscribe so you can be notified next time I upload a video. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.